How much debt do you need to file for bankruptcy? Section 1. The hook and the illusion of the magic debt threshold. What is the exact dollar amount of debt that you must carry before you are legally allowed to file for bankruptcy? If you spend any time scrolling through internet forums, financial advice blogs, or listening to neighborhood rumors, you will hear people confidently cite a magic number. One person will tell you, "Oh, you have to owe at least $50,000 before a judge will look at you." Another will say, "Don't bother unless you're at least $100,000 in the hole." The internet is filled with financial myths that keep people trapped in fear and confusion. And unfortunately, many families delay getting help because they believe those myths are true. This misinformation leaves thousands of people stuck in a horrible financial limbo. They think they don't owe enough money to qualify for legal relief, so they continue to suffer under a smaller amount of debt that is completely destroying their life. They keep making minimum payments month after month while the interest quietly consumes their future. And emotionally, the stress of that debt becomes heavier with every passing week. Today, we are going to look at the actual statutory truth. Hi, I'm Sean Quinlan, a consumer bankruptcy attorney right here in Pennsylvania, and we are answering the foundational question: how much debt do you actually need to file for bankruptcy? We are going to look at the exact wording of the United States Bankruptcy Code, expose why bankruptcy eligibility has nothing to do with a specific dollar amount, and give you the exact real-world framework to calculate your personal tipping point for total financial relief. Because once you understand how bankruptcy law actually works, the fear starts to disappear. And instead of feeling trapped, you finally begin to see a path forward. Section 2, Relational Insolvency, Math versus Hard Numbers. The reason there is no minimum debt requirement is because the federal government recognizes a profound economic truth. Debt is entirely relative. A dollar amount that is a minor, easily manageable bump in the road for one household can be a massive, cataclysmic mountain of financial ruin for another. The law doesn't look at the raw number on your statement. It looks at your ability to pay it back based on your unique income and asset structure. This is what we call relational insolvency. Bankruptcy law is designed around financial reality, not shame or arbitrary numbers. The system exists to evaluate whether the debt is realistically sustainable for your specific life situation. Let's look at an explicit, real-world comparison to see how this works. Because once you see these two households side by side, the entire concept becomes crystal clear. The same debt amount can create two completely different financial outcomes. Imagine household A. This is a high-earning corporate executive making $250,000 a year. They have excellent liquid investments and significant disposable income. If household A accumulates $15,000 in credit card debt, that is a minor issue. They can alter their budget for 2 or 3 months, cut back on luxury spending, write a series of large checks, and completely wipe out that balance without ever needing a court. For household A, filing for bankruptcy over $15,000 would be completely unnecessary. Now, let's look at household B. This is a retired grandmother living in York County, Pennsylvania. Her only source of income is a fixed Social Security check of $1,400 a month. Her basic living essentials, her modest rent, her prescription medications, her utilities, and her groceries equal exactly $1,350 a month. She has exactly $50 of disposable income left at the end of the month. If household B is hit with that exact same $15,000 of debt, perhaps from an unexpected medical emergency or a high-interest credit card used to survive, she is in a state of absolute structural insolvency. With $50 a month in disposable income, it would mathematically take her 300 months or 25 years just to pay off the principal balance without even accounting for interest. For this grandmother, that $15,000 of debt is just as devastating as $5 million is to a corporation. It is an unpayable mountain. The Bankruptcy Code is built to protect household B just as aggressively as anyone else. Section 3, the 3 to 5 year operational rule. So, if there is no magic dollar amount written into the law, how do you determine if your debt is substantial enough to warrant a bankruptcy filing? In my practice here in Pennsylvania, we use an operational rule of thumb called the 3 to 5 year horizon rule. I want you to sit down with your actual financial documents and perform a very simple, honest calculation. Look at your total unsecured debt balances, add up all the credit cards, medical bills, and personal loans. Now, look at your actual take-home income and deduct your true, necessary, everyday cost of living, your housing, food, transportation, insurance, and utilities. Look at the cash that is left over. If you take that remaining disposable income, dedicate every single penny of it to paying down your debt principal, and the math shows that you cannot realistically and completely clear those balances within the next 3 to 5 years, you are the exact textbook definition of an ideal candidate for bankruptcy. Section 4. Assessing the true cost of filing. Now, let's look at the practical side of the equation. While there is no legal minimum to file, there is a practical minimum based on a simple cost-benefit analysis. Filing for bankruptcy is not free. The Federal Bankruptcy Court charges a mandatory filing fee of $338 for a Chapter 7 case and $313 for a Chapter 13 case. On top of that, you have to pay a licensed bankruptcy attorney to prepare your complex schedules, execute the means test, attend court meetings, and manage your asset protections. If you only owe $2,000 in total debt, it makes absolutely no financial sense to file for bankruptcy. The cost of the court fees and the attorney would equal or exceed the total amount of debt you are trying to erase. In that situation, we would advise you to simply settle the debt or look at a basic budgeting solution. Section 5. Conclusion and Strategy Invitation. Stop waiting for your debt to reach an arbitrary, scary number before you grant yourself permission to seek professional help. The law does not require you to be completely destitute before you claim your right to a clean slate. It simply requires you to be stuck in a mathematical trap that you cannot escape. If you are ready to stop guessing and want a professional, data-backed cost-benefit analysis of your specific income and debt structure right here in Pennsylvania, let's sit down. Click the link below in the description box right now to schedule a completely free, 100% confidential strategy consultation with our office. We will run the numbers honestly, tell you if bankruptcy makes sense for your family, and help you take your life back. If this video cleared up your confusion, please hit that like button, subscribe to our channel, and drop your debt questions in the comments below. I'll see you in the next video.